to see members of the committee. The public member committee meets monthly by Zoom, and we talk about topics that are of interest to public members. And 4 times a year, we open the session to anybody who's interested, and we have a subject-specific presentation, often with the guest speakers as we have today, on topics that we think interest not only public members, but other members of the certification world. These sessions are recorded, as Katie said, and past sessions are available on the public member resource page, which you can find on the I.C.E. website under communities. And I encourage you to look at back and enjoy back presentations, network calls like this one. Also, those of you who are not members of the committee but belong to I.C.E. member organizations, please include your public members on your organizational profile so that they receive things like newsletters from I.C.E. and other announcements on their email, and also encourage them to attend the exchange. Public members registrations are waived by I.C.E. if they attend with their CEO or their board chair. So please encourage them to attend and encourage them to make them aware of our public member committee. So turning to our presentation on challenges, political and other challenges that certification is facing, and also one notable success. We have 2 speakers this morning. First one is Don Balesa. He's an attorney, an MBA, and he's the CEO and legal counsel of the American Association for Medical Assistants in Chicago. Balesa was chair of the National Commission for Certifying Agencies, NCCA, and is currently co-chair of the main committee that's updating the I.C.E. Standard 1100, which is a standard for assessment-based certificate programs. He also serves on the I.C.E. Accreditation Services Council. Balesa received both his baccalaureate and law degrees from Northwestern University and his MBA in economics from the University of Chicago. Our other speaker is Mark Franco. He's the outside counsel for multiple professional and trade associations, public and private foundations, religious organizations, certification and accreditation bodies, advocacy organizations, political action committees, social clubs, and other nonprofit tax-exempt organizations. He has substantial experience handling matters involving accreditation and certification standards, DEI, and test administration, among other topics of interest to credentialing. He is an I.C.E. certified credential professional. With that, let me turn the microphone over to Don.
Thank you, Becky. Hello, everyone. It's great to see faces of longtime colleagues and new colleagues. I appreciate this opportunity to present, and especially to present with Mark. I've heard him speak and read his articles, and he is a consummate professional. So I think we'll cover a lot of material. I'll be talking about a memo from Attorney General Bondi, and I have a handout that will be up on the screen shortly. And Mark will be talking about the legislative victory in Congress recently in amending Section 529. And if there's time, I might talk a little bit about the Workforce Pell Grant Program, which is part of the One Big Beautiful Bill Act. Now, this memo from Attorney General Bondi has gotten a lot of commentary, some of it accurate, some of it not accurate. So I tried to quote from it as much as possible to go to the original source. A lot of this affects schools and accreditation more than credentialing. However, you'll see that there is a lot of overlap. So let me try to go through this quickly. First of all, this memorandum is not legally binding. Nevertheless, it's important to pay attention to it because it will guide a lot of decisions that are made. The second point, this memorandum is applicable to parties subject to federal anti-discrimination laws. Now you see in the block quote that there's a reference to entities that receive federal financial assistance being under the jurisdiction of this memorandum, and that's true. However, it's been sometimes neglected that this memo also applies to parties that are otherwise subject to federal anti-discrimination laws. So keep that in mind. And examples of federal anti-discrimination laws are, of course, Title VII of the Civil Rights Act of 1964, which governs discrimination in the work setting, and that applies to entities that have 15 or more employees. So it's wrong to think that this only applies to parties that are receiving federal financial assistance. The next heading is discrimination on the basis of protected characteristics. And the gist of this memo is that type of discrimination should be scrupulously and virtually universally avoided. Now, the protected characteristics under Title VII are the familiar race, color, nationality, sex, and religion. And this memo does focus on those to a great extent. The last heading, proxy discrimination, should be avoided. And I want to pay some attention to this because this, I think, is a change and a tightening of the requirements. You see in the second paragraph, overcoming obstacles, narratives, or diversity statements. Now, again, I'm quoting, a federally funded program requires applicants to describe obstacles they have overcome or submit a diversity statement in a manner that advantages those who discuss experiences intrinsically tied to protected characteristics using the narrative as a proxy for advantaging that protected characteristic in providing benefits. So this memo is saying that using these proxies for one of the protected characteristics, race, nationality, etc., that also is contrary to the position of the Trump administration and would be a violation in the eyes of the Department of Justice of the Trump administration of the federal law. So keep that in mind. Now let's move to the bottom of this page. These other headings are primarily related to schools and accreditation bodies, and some of you may be interested in that as well. But I want to look at unlawful DEI training programs. And this memo states that they should be avoided. But my point is that not all DEI training programs are necessarily unlawful. So let's look at what was there a comment or a question from someone? Okay, let's look at what this memo says are lawful and unlawful DEI training programs. Unlawful DEI training programs are those that, through their content, structure, or implementation, stereotype, exclude, or disadvantage individuals based on protected characteristics or create a hostile environment. This includes training that excludes or penalizes individuals based on protected characteristics, and secondly, creates an objectively hostile environment through severe or pervasive use of presentations, videos, and other workplace training materials that single out, demean, or stereotype individuals based on protected characteristics. So I want to direct your attention to this because this memo is saying that is implying that there are DEI training programs that do not violate federal law. And I put those into three categories. One, or rather, what I'd like to do is say the three categories that create an illegality are, first of all, those programs that are exclusionary. Secondly, those that penalize or are punitive toward protected characteristic. And thirdly, those programs that create a hostile environment. And I know questions that I've been receiving are, what if a certifying body requires that its certificates complete 3 hours of DEI training or called something else in 3 years in order to recertify? And I think there's been an overemphasis on how that's going to cause problems. My point is that it is very possible to create a lawful, a legal, a permissible DEI training program as long as it's not exclusionary or penalizing or creating a hostile environment. You might ask, what is a hostile environment? A quick example is a training program that takes the position that all men are chauvinists, all men demean women, and we can think of many other examples. But I would encourage all of you to not shy away from offering these programs or requiring these programs for your certificates or your licensees. I know there are some representatives of licensing bodies on this presentation, so keep that in mind. Let's
Don,
move
can I make
now.
a quick comment?
I'm sorry,
Yes,
go
Mark.
ahead, Mark. Yes.
Yeah. So I think this is a really good point, just to put a little bit more emphasis on it. So the administration's position isn't that all DEI is unlawful. I mean, they specifically use that word unlawful discrimination in their communications. So, you know, we shouldn't, as a community, we shouldn't be afraid to continue to try to make efforts and put emphasis on programs that include people, that look to diversify your candidate population, things like that. Of course, you want to be very thoughtful, just like anything. You want to be very thoughtful, and um, that's where your roles as public members. That's where they're really important in that making those processes thoughtful. But we shouldn't, we shouldn't shy away from the work.
Thank you, Mark. I totally agree with that. And again, I'm seeing some undue shying away. People have asked me, well, I have a DEI speaker on my website giving a talk. Should I remove that? Or we have a program in our upcoming conference that mentions DEI. Should we remove that from the title? I think that's a little bit of an overreaction. So I totally agree with that. Thank you. And I want to mention that if there are any questions throughout the talk, just raise your hand or do whatever is necessary because we'll try to get to those and yet cover all of our material. Now let's go to the very bottom. Again, some of the parts I'm skipping are more relevant to schools and the like, but legal opinions. First of all, it's my legal opinion that private sector certifying bodies and associations, regardless of whether they receive federal funding. So again, don't make that the ultimate test. It is a test, but it's not the only test. If you're subject to federal anti-discrimination laws, such as Title VII, then you are subject to what we're talking about. So I claim that private sector bodies could be sued successfully under Section 1981 of the Civil Rights Act of 1866, post-Civil War statute, if they offer race-based scholarships or programs. Now, this is surprising to some people, maybe even counterintuitive, that Section 1981 says that any contract that discriminates on the basis of race is illegal. So how do you tie that in with what we're going to talk about in this paragraph? Scholarships that are presented, or in the case of this firm in Atlanta, providing Black women who run small businesses special opportunities. The thinking of the courts has been that the offer and acceptance of some sort of benefit does fall under the definition of contract in this 1866 statute. And therefore, this private group, the American Alliance for Equal Rights, has been suing some of these private parties, claiming that by offering special scholarships or whatever, they're violating that statute. So note that this is not a case that was brought by the federal government. The American Alliance for Equal Rights is similar to the organization that sued Harvard and the University of North Carolina and won the case in the United States Supreme Court. I think many of you are familiar with that case. But this group, this anti-reverse discrimination group, sued two law firms who offered Black law students diversity fellowship after their first year of law school. And as I mentioned, there's this Atlanta-based venture capital fund that offers grants and resources to Black women who run small businesses. And the lawsuits were settled out of court because these two law firms and this venture capital firm realized that they would probably lose the suit. So just beware of that in case you're wondering whether you could be exposed to any civil liability in this regard. Secondly, I'll repeat my point, private sector certifying bodies that require continuing education on DEI, etc., should not discontinue those if they can frame them in such a way that they're not exclusionary or punitive or create a hostile environment. I hope all of you take that to heart and heed what Mark said a few minutes ago. Now, point number 3 is controversial. I've been asked questions about this, and I can't really make a definitive legal statement here, but the issue that I've dealt with is whether private sector certifying bodies can create a certain number of seats for representatives of protected category populations. Is that going to be a basis for a lawsuit? And I take the position that having a certain number of minorities or whatever on a certifying board or a test construction committee or any type of panel like that, I don't think would violate any law and would not run afoul of the Trump administration's position. And my reasoning is that creating these positions does not confer a benefit on those individuals, such as a scholarship or admission to a school or a job offer, a promotion, or acceptance into a mentorship program, or a summer internship at a law firm, as we talked about, or special benefits to Black women who run small businesses. I don't believe those would be considered benefits, and therefore I don't think a certifying body would have a high likelihood of being sued successfully on the basis of this 1981 section that we talked about above. Again, that's my best opinion. It's conjecture. We don't have any cases on that. But note my next point in parentheses. There is another case that involved a suit against the state of Louisiana. In fact, why don't we go to the next page if we could, Katie? I don't want to spend a lot of time on this, but essentially, Louisiana law says that in this instance, the Louisiana Board of Medical Examiners has to make sure that every other new appointment has to be a representative of a minority population. And another one of these anti-reverse discrimination groups sued the state of Louisiana, claiming that that's a violation of the Equal Protection Clause of the 14th Amendment. So a very straightforward legal theory. So the issue before that federal court in Louisiana is whether this language, and you see me quoting it there, at least every other member appointed from a list provided in this paragraph shall be a minority appointee. So very straightforward. And of course, the wording of the Equal Protection Clause of the 14th Amendment, which applies to the states, clearly forbids denying equal protection of the laws. But again, the issue is whether the situation in Louisiana with the statute saying that there have to be minority appointments to the medical board. Actually, that applies to a lot of other professional boards in Louisiana as well, would run afoul of the Equal Protection Clause. And let's just go to the very bottom of that page. Again, the 14th Amendment very straightforwardly says that no state shall deny to any person within its jurisdiction the equal protection of the laws. I won't go over the other points, but are there any questions at this point? If not, I'll turn it over to Mark to talk about section 529.
Well, Don, let me just add on to what you said too. So,
Please.
there's nothing that prohibits organizations from continuing to try to have diversity in their workforce, diversity in their governing body. So I think there's ways to attempt to continue to do that without necessarily implicating some of these laws. So, what if you followed the Student for Fair Admissions versus Harvard case? I mean, the problem there was that even though, and this is where a lot of the proxy arguments have come up, even though the processes that were used were meant to create diversity, it looks like, at least from the numbers, that Harvard was just trying to create certain categories and keep those categories the status quo. And so it was, I think it was hard for them to argue that the primary goal was diversity, because they were just putting people into racial buckets. I think if you're trying to do that with your governing board or your committees or whatever, then you may be facing the same challenges. But if you just go from the overall, if you go from an overall goal of just making sure that there's equal representation on your board from all of the stakeholders that you believe are important to your profession, to your candidates, to your program, then I can't see necessarily that being a problem.
Right, I agree completely. And you reminded me of another point that I skipped when I talked about how I don't think a certifying body could get into trouble if it says that a certain number of people on their board or their item writing committee or whatever have to be from a certain category. The language that is often used is that from certifying boards that currently do this, is that they have these positions to ensure adequate representation of all segments of the candidate population. That's a good clause that is already being used. And so I think that addresses the point that you just made, Mark. But I would say that it can go even beyond that. If there's a need for the profession or the occupation to be able to reach in terms of consumers or clients or patients or whatever, certain categories, I think that can also be a basis for that. Would you agree with that, Mark?
Yeah, absolutely.
Okay. All right. Any questions before we go to 529? Yes, Becky.
Yes, I have a question. You passed over the points about accreditation of academic institutions, but is there any implication for certifying organizations that require, for eligibility, education at an accredited organization, or continuing education at an accredited organization? Are there any implications for certifiers in the?
Yes, that's a relevant question. Thank you. And my answer to that is I really don't think so. I think the connection is too remote between what a school does or an accrediting body does in terms of requiring preferences and what the certifying body does in terms of eligibility criteria. So I think that's too much of a stretch. Another question that I've gotten in these events in the last few months is what if there's an applicant who receives federal funding to pay for the exam, does that somehow invoke the full panoply of these federal requirements? And my answer there is no. And I think Julia Judish also said that she thinks
Mhm.
there would be no connection to make that federal funding in the category of federal funding for a certifying board, just because a certain number of candidates receive federal funds to pay for the exam. I see that Tom has a question. Hello, Tom.
Can you guys hear me okay?
Yes. Mhm.
Yeah. So I'm sure I agree with you on the direct implications for certifying bodies, especially private certifying bodies. But getting specifically to Becky's concern, the Accreditation Council for Graduate Medical Education was basically told in no uncertain terms by the federal government, by this administration, that if they didn't eliminate their DEI programs altogether, they would not be receiving federal funding. And of
Right.
course, the
Yeah.
medical the education system is dependent on federal Medicare funding. So they announced last week that they were eliminating their program. So, in the instance, a specific decision to represent stakeholders or represent constituencies on a committee or on a board might not be threatened by the law. But as a practical matter, the elimination of the organizational capability to manage that process may be a threat. And I'm wondering the question I have that's specifically relevant to you, and I apologize, I only got on a few moments ago, so I'm sort of jumping in the middle of this. But what I've been wondering is whether any states with similar attitudes towards DEI, and there are half of our states or more, are exercising the same kind of financial leverage at the state level that is being leveraged at the federal level.
Yes, that's an important question, Tom. Thank you. I am aware that there are. I haven't studied that. I can't really go into detail. Maybe Mark, you're more aware of that, or anyone else
Yeah.
on this call. And before we do that, your point, Tom, is very good. If you have a certifying body or a licensing body for that matter that says we're only going to allow candidates who are graduates of a program that is accredited by a certain accrediting agency, and if the federal government in effect shuts that down, that agency down, and again, the reality is that unless a school is eligible to receive Title IV funding under the Higher Education Act, it's not going to be able to survive. There's some exceptions to that, but basically that's the principle. So you're right, the end result could be the same, even though it's not a direct connection between the
Right.
licensing or certifying body. But yes, studying these state laws is very interesting. Mark, have you done any work in
Yeah,
that
I mean,
area?
even before the executive orders came out, there were a number of states that had already adopted laws that were affecting higher education, and and the prohibition of DEI within their programs. Um, I want to say Florida, Missouri. I mean, I can't rattle off every one, but I want to say there are at least 7 or 8 that already had adopted some form of legislation. And so
Mm.
it was a trend at the state level, and it seemed to be targeted at higher education for the moment.
Thank you.
Okay, Mark, take it away.
Yeah, and Don, feel free to jump in. So when Don asked me to present to this group, it's not often that I um, have sort of a broad discussion with public members, and it's a little bit of a different conversation because your role is very specific, right? In terms of what you're doing for the organization, how you have to present a very broad public interest. And so I'm going to be talking about 529, but I also just wanted to put a couple of things on your radar so that it's just some food for thought as you work with your individual organizations or more broadly in whatever public member role you serve. So the first one I just wanted to introduce is there was a executive order that came out on April 9th that didn't get a lot of attention from our community, but it has some very curious language in it. So I'm going to share my screen just for a second. Let's see. So this is the executive order. Can everybody see that? So it's
Yes.
called Reducing Anti-Competitive Regulatory Barriers. And it calls for agencies in consultation with the chairman of the FTC to review regulations and identify potentially regulations that create or facilitate licensure or accreditation requirements that unduly limit competition. So this is the first time, I think, or this is one of the, this hasn't really been talked about, this perspective potentially that the administration and others may be taking in this view that accreditation is an anti-competitive is an anti-competitive process. You know, most of us view accreditation as something that's very beneficial, right? Very beneficial to the program, very beneficial to the public. And so we've not really heard it described in this way. I haven't seen a lot of movement in terms of acting on this particular statement here or other conversations, but I just wanted to put this out there for you all, as you know, just to, if you haven't heard this talked about in your circles, maybe this isn't something that part of the conversation that you can bring again to the organizations you're working with, or the or in your broader role, because you know, for us, when we think accreditation, we think of I.C.E, but accreditation, that term is used in many different ways, right? You have accredited CE programs. Maybe your organization has accredited CE providers. And so this potentially is a hook for somebody to make an argument that what is going on may be anti-competitive. Yeah, Mark, you had a question.
Wasn't there right after the election, or maybe right before it, a Department of Justice public comment piece that basically asked for people to provide examples of things that made it difficult for people to practice? Tom, you may remember this, but it seemed to be a reaction from some parts of the medical profession that were particularly concerned about recertification, and seeing it as a block to being able to practice.
Yeah, there was a whole initiative called the Freedom Initiative in the first Trump administration, specifically. So this has actually quite some history. It hadn't really occurred to me that the continuing education system, which in medicine is really designed primarily to prevent the infiltration of commercial interests into education, which we rely on to make sure that medical education is for medicine. And I don't know if it's true for other professions. So this is very worrying.
Yeah, and the point is that this seems to be Mark, it seems to be a trend of the administration that sort of borders on our work. But
Yeah.
I appreciate you pointing this out, because it's one of the things we need to pay attention to.
Yeah.
Yeah, and I know that I.C.E is planning to have more conversations in this space, but there's also been a report that's come out of an organization called Burning Glass, where they are essentially trying to discredit the value of credentials, saying that they're not, they don't lead, credentials actually don't lead to improved professional outcomes for individuals. So, again, just so want to make sure that this is on everybody's radar, because it is an important piece of how or our, the groups that we work with are interacting with the broad general public. So I'll stop there for any questions.
Can you put a link in the
Oh
Burning
yeah,
Glass
absolutely.
report?
Yeah.
There's
I've not
also
heard
almost
about
complimentary Wall Street Journal article that we can drop in as well.
Okay, I'm gonna stop sharing here.
Right, I agree with you, Mark and Tom, and that's a very important issue. So we definitely should pay attention to that.
I'm not sharing anymore. Am I still sharing?
Yes, you are.
Okay. Let's see, how do I stop sharing? How do I stop sharing?
That's because you're a very sharing person, Mark. That's a good thing for you.
Check down at the bottom of your screen, Mark. There you go.
Yeah,
Click
it's
on
the share button is there, but it doesn't give me an option to not share. Oh, here we go. It's at the top.
So,
Okay, there we go. All right, so the other thing that I wanted to bring to your attention is that last year a report came out about nonprofits in general and the trust that the general American public has. So this was and here I can try and put this link to this link. I'll put it in a second. So this was from my nonprofit advisor, and they did a survey, and the survey brought back that 59% of the general public, they hold nonprofit organizations in a very high level of trust. Okay, 59%. And the summary touted this as a win, because it was a higher score than any other of the major sectors of industry got. Okay, but if you look at the number 59%, that means over 40% of people don't have a high level of trust in nonprofits. And why is that? Right? There's another report that I've shared with that's related to this that I've shared with I.C.E, and I'll work with them to get it to you folks. But one positive factor that was included is that actually the process of credentialing and certification that increased the level of trust between the public and and the nonprofit. So again, I'm not sure where all of this fits in the conversations that we're having today, but I think these are important things for you to have on your radar in your public member role.
If I can just say, the level of trust is pretty low in general among Americans for institutions of all kinds. And physician trust is sunk down to about the same level, about 60%. But nurses continue to be high, but even they're among the highest. Nurses are among the most trusted profession in the country, but still 1 in 4 people don't trust them. So, for what it's worth. But I agree with you. This is a huge issue. This is what I spend all my time thinking about. So thank you for the note.
Mark, did you say you were going to share a link to that study?
Yeah, I'm pulling it up right now.
Okay, thank you.
Okay, here it comes. Okay, so we're going to pivot. If there are no other questions, we'll just pivot very quickly to the talking about the 529. So this has been a huge win. And if your organization is part of the Professional Certification Coalition, they've put out a really great fact sheet on how the changes to the 529 help certification and credentialing bodies. If not, it's generally available. So let me put that link here too in the chat. But I thought it would be helpful just to sort of cover the basics of 529 and then the basics of how they would really serve the organizations that you work with as public members. So 529s, they're financial plans that are administered at the state level for people to be able to use after-tax funds to pay for certain types of authorized expenses, mostly related to education and professional development. So even though the benefit of having a 529 plan goes beyond just where you live, you do have to work with your particular state to set up a 529 plan. 529 plans are after-tax dollars, so they're created with after-tax dollars, but whatever you put in grows tax-free. And what's really great about a 529 plan is you can actually change beneficiaries. So if you start one up for your child, you could actually change the beneficiary at some point to be your grandchild, right? If you don't use all the funds. So I'm not sure, where everybody's knowledge is on 529s, but they're really, really useful tools, especially now when the cost of educations are so high, or where there's, really great opportunities for workforce development in these alternative paths with certification and other types of workforce development programs. This is a really great tool for individuals to be using, and a really great resource that your organization could be touting for the people that are going through your certification programs. The 529 plan can be used not just for the certification fees, it can be used for the test prep fees, it can be used for the continuing education requirements, can be used for the recertification fees. So it's a really, again, really, really useful tool for managing all of these types of expenses. Don, did you have anything you wanted to add about 529 plans?
Just that, I think you hit all the key points, Mark, and I would encourage everyone to be aware of that, because even if it's not applicable to your situation, you might get questions about it. So I think it's a very flexible system, as you indicated, and it actually is relevant to what I'm going to talk about next. So yes, I think you've covered everything, and we thank the American Society of Association Executives,
You do have a copy.
I.C.E. We thank the Professional Certification Coalition. So yes, please
Yeah,
look
and
into
let me
that.
also just say that you can access this program now. So it's available now. Whether or not your state, though, has the ability to administer it, that's a different question. So you're going to have to contact the state administrator for the 529 plans, but the law is active now. So that's all I had on that, Don. If you want to talk about the Pell stuff.
Yes, okay, very good. But first, are there any questions for Mark about any of the important points he mentioned? Okay, if not, Katie, could you pull up my handout again? And by the way, my documents are, could we make those available to everyone, Katie?
Yeah, I'll load them into the chat at the end of the call.
Yes, by all means. Feel free to distribute them as you think best, because we want to get the word out. This is not at all proprietary information. My purpose is to inform and to educate. Okay, now the One Big Beautiful Bill Act, I understand that the insiders call it OB3. So you all know the key points, but let's go back to the top of that if we could, Katie. Okay, so this act was signed on July 4th, and it created a new program known as the Workforce Pell Grant Program. And this, I'm going to provide some definitions. We're familiar, I think most of you are familiar with the traditional Pell Grant program, which is for programs in traditional schools. But this is a different animal. This is the Workforce Pell Grant program. And it states that individuals and the program itself is able to participate in this program if it provides education that is, quote, aligned with the requirements of high skill, high wage, or in demand industry sectors or occupations and meets the hiring requirements of potential employers in these sectors or occupations. The thrust behind this is to make funds available for individuals who don't want to go through a formal educational program, but want to get training, if I could use that term, to be prepared to enter the labor market in a particular role. So here are some quotes from the bill. The programs that are offered to be eligible under Workforce Pell must lead to a recognized post-secondary credential, and that would include certifications. So please take note that is stackable and portable across more than one employer. The credentialing community is also familiar with stackability, portability. So this is of relevance for certifying boards. And it must prepare students for employment in an occupation for which there is only one recognized post-secondary credential, and provide students with such a credential upon completion of the program. Now note the next provision. A program to be eligible must ensure that the program completers receive academic credit. So that's a dimension that must be taken into account, that will be accepted toward meeting the program requirements of a certificate or degree program at an institution of higher education. You see the attempt to link these credentials with higher education, in addition to the credentials themselves being stackable and portable. Note that programs offered as correspondence courses are not eligible to participate in this Workforce Pell Grant program. What about the length of these programs? Note that a program must be at least 150 clock hours of instruction, but less than 600 clock hours. So there's an upper limit and a lower limit, or an equivalent number of credit hours offered by an eligible institution during a minimum of 8 weeks, but less than 15 weeks. So we're talking about short programs, 8 to 14 weeks. Again, the thrust is obvious. The next question, and this was highly debated in Congress, which institutions of higher education are eligible to participate in Workforce Pell? And note this, that the institutions of higher education that are eligible are the same ones that are eligible to participate in the traditional Pell Grant program, namely those schools that are accredited and can receive funds under Title IV of the Higher Education Act. There was some concern that the providers of this training would not have to be traditional schools, but could be any education provider, continuing education provider, whatever. But the final version of the bill did indicate that these programs that are eligible for workforce Pell funds have to be those same schools that are eligible to receive Title IV funds under the Higher Education Act. Okay, which students are eligible to participate in this program? Now, this is quite interesting. It states that a student eligible for the program may not be enrolled or accepted for enrollment in a program of study that leads to a graduate credential or have attained such a credential. So students who have a bachelor's degree, but not a post-baccalaureate degree or graduate credential are eligible for a workforce Pell Grant because there are individuals, an increasing number, as it's been reported, who have a bachelor's degree that still haven't found their niche in the workforce and might be interested in taking one of these short programs, 8 to 14 weeks, and be prepared for a particular job in the current labor market. So those individuals are eligible, but not someone who has a post-baccalaureate degree or a graduate credential. The focus of this bill obviously is for those who want to enter the workforce in a particular role that's in high demand. All right, the final question, once an educational program is deemed eligible, what ongoing requirements must it meet? So these are very important. The program must meet these requirements or it will be dropped from the list of programs that are eligible for workforce Pell. For each award year, completion rate of the program of at least 70%, within 150% of the normal time for completion. And that time of completion is important because otherwise these programs can be stretched out over years, and that would defeat the purpose of this legislation. Secondly, has to have a verified job placement rate of at least 70% measured 180 days after completion. Once again, it's obvious that the emphasis is getting people trained so they can enter the labor market. It's not to get people educated in disciplines that will not have a more direct connection to employment. Now, the third point is worded a little bit awkwardly, so I'll just summarize it. The additional earnings that these trainees or students receive by virtue of having completed one of these programs must exceed the cost of the program. So if a program costs, let's say, $5,000, there must be a showing that the completers of the program are able to increase their income by an amount greater than $5,000. And some of you may be familiar with the gainful employment policies in the Department of Education and in Congress that were trying to make sure that programs who charge perhaps a high tuition to students, and some of those students are not able to find employment or at very low salaries. This is another attempt at trying to make sure that people who complete these short workforce Pell Grant programs are able to be employed and are able to make something that is greater than the cost of the program. In other words, there has to be a showing that the completers are better off than they were before they took this program. And one way of doing that is to show that they increased their income in an amount greater than what they had to pay for the program. So again, the public policy behind this is very clear. I've heard some people argue that it's a good idea. Others argue that it might detract from the traditional educational system. But again, I think this relates to what Mark was talking about in terms of 529, because an individual can participate in one of these programs that would be eligible for workforce Pell. And if the workforce Pell doesn't cover 100% of the costs, the balance that they have to pay out of pocket could be paid for by means of withdrawing funds from the 529, as Mark explained. So this is very relevant for the certification community and for the public at large. Are there any questions about the workforce Pell Grant program or its difference, the differences between workforce Pell and the traditional Pell? Okay, so put that on your radar screen. Oh, yes, it was okay. Any questions on anything we've talked about? Or
I
Mark,
have
you?
I have a question on something you probably haven't talked about.
Okay.
It's curious to know. Um, the military has been very supportive in general of achieving certifications of various kinds through education and training for in all the services, and they have the rules are a little obscure because every service has slightly different rules, and a lot of the decision making around whether the certification is going to be recognized. And they will pay for the recognition and for the training, the certification and for the training. I guess what I'm wondering is whether you've heard or know of any efforts to strip those from the through the Defense Authorization Act from the military rules to basically undermine the ability to certify privately.
I haven't heard that, Tom, and I suspect that's not going to happen. I think Workforce Pell and other programs would probably be in addition to those, not to replace them.
Okay.
Does anyone know anything to the contrary? Okay, we're coming to the end of the session, but any final questions? Or Mark, do you have any other comments for us?
I see Becky has a question.
And this is with a minute left, this is a terrible time to ask this question, but can you share with this group through the chat or through an email anything you know about the threats to the tax status of nonprofit organizations or certifying organizations?
I suspect Mark is more knowledgeable than I. I'm sure he'd be happy to do that.
Yeah. So there was a lot of well the bottom line is the one big beautiful bill that passed, and that was the primary threat to the tax exempt status of many of the organizations we worked with. Fortunately, not all, but like 95% of the provisions related to nonprofit tax exempt organizations were stripped out of that bill and did not get passed. But that doesn't mean the threat ultimately is going to go away. The federal government has a really huge problem with its budget, and as long as that continues, I think lawmakers on both sides of the aisle are going to continue to look at this sector as a potential source for filling some of those gaps.
And Becky, I can just add that I.C.E. has joined the coalition with ASAE on the tax issues. We were part of the deliberation that Mark is talking about to have it stripped out of this last bill, but the threat continues moving forward in each budget discussion. So we'll keep our ears open.
Yeah, and I think one of the proactive things is to better describe how nonprofit reserves work, because one of the things that happened in the bill was tax charges against college endowments. You know, reserves are not endowments. So and I always try to think proactively, and it's like, what can we do to kind of stave off the clutches of the federal government in this case to, I think in an effort to penalize nonprofits more than an effort to generate revenue.
Let me just conclude by pointing out my background. I'm going to be speaking at the annual conference of the Council on Licensure Enforcement and Regulation next week in Chicago. There's also a virtual option. And I'll be speaking about some of the things I touched on today and some other issues. Grady Barnhill, who's on this call, will be co-presenting with me. So that's clear. Council on Licensure Enforcement and Regulation. As I say, there is a virtual option, so I would encourage all of you to look into that. And that's all I have. Thank you. Thank you, Mark.
Thank you very much, Don and Mark and everyone else for this conversation.
Thanks, everyone. Have a good day.
Take care.
Thank you.
Thank you.
Thanks.